Is it really a surprise that Kouri's staring down this witness and rolling her eyes? Cody is still on the stand, and Cody Wright was Eric's business partner in C&E Masonry, a business that they had 50% partnership between the two of them. And it was a company that was started back in 2012. Now, there came a time where it seemed like Eric realized Kouri had taken this $250,000 HELOC that we've been talking about over and over again. And maybe, just maybe, Eric was concerned that Kouri didn't have the means, wasn't profitable enough to pay the money back. So C&E seemed to have loaned money to Kouri's business to bail her out of one of her projects. That's what it seems like from the testimony.
Did there come a time when C&E assisted Kouri Richins Realty?
Yes.
How did that come about?
Oh gosh, the HELOC?
Eric called me, was distraught. I said that some things had happened in their home that.
Is that to hearsay?
Sustained, please rephrase. Or just keep moving.
Your Honor, can we approach?
Sure.
All right, what is happening in Sidebar? The court. Are you going to object regarding foundation that he knows about this conversation? Miss Nestor, I don't even know what conversation he's talking about, but the court. It's going to be Eric complaining about the HELOC, I imagine. Mr. Bloodworth with the state comes in. Well, Your Honor, the state's offering it for the effect on the hearer. Eric's going to complain about the HELOC and ask Kouri if, gets interrupted by the court, ask Cody, Mr. Bloodworth. I'm sorry, ask Cody if he can use C&E money to bail out a project. The court, to bail out what? Mr. Bloodworth, one of Kouri Richins Realty's projects. Oh, okay. And so I need to lay the foundation of why Cody said it was okay to use like $200,000 of C&E money to assist Kouri Richins Realty. Now remember, Kouri Richins Realty is Kouri Richins' real estate company. The court says, okay, Miss Nestor, and he can do that without what Eric told him about it. The court, I don't know how. That's hearsay? Well, I know, but how he's going to get any of that foundation... It's fine with me if he doesn't. I mean, he can't bring in hearsay to get something he wants in. He doesn't want Eric's statements in. He just wants to get in this gentleman's testimony about what they did and why. Well, he can just ask him, did he use C&E money to bail out or to invest in one of Kouri's properties without saying what Eric said about it? The court. So this comes back to my first question. Are you going to object regarding the foundation? No. Okay. No, not if if he does it that way. Tell me what's missing here. I'm not sure what that way is. What is that way? The court. Just ask him if they use C. Just ask about what they did rather than the conversation. Tell me, is there a why piece that I'm missing here? The why piece is that it was extraordinary and that it was only time gets interrupted by the court. Well, you can ask all that. And it was because the reason he did it is because Eric was scared of losing his house. That's why, Cody said it was okay. Miss Nestor. Well, I object to that of Eric telling him that. I object to that. The court. Yeah, that would be for the truth of the matter. You can say it was extraordinary. You can say even that Eric asked him to. Miss Nestor. Without what he said exactly, right? Yep. Okay, very good. Now they go back to the open court. Oh my gosh, I thought one of my dogs gassed the room because I was like, what is that strong smell? But then I opened the door. It's what my roommate just microwaved food. But I don't know, man. With Cheryl's gassiness is sometimes very dense. I think we feed him a little too well.
Sir, did there come a time when C&E assisted Kouri Richins' business?
Yes.
How did C&E, without saying anything that Eric told you, how did C&E assist Kouri Richins' business?
There was a loan that was needed to be had for that business that was asked for, where C&E would provide the funds to fund a project, and C&E did provide those funds.
Was that a loan rather than an investment?
It was a loan.
Was it in extraordinary circumstances that caused C&E to loan Kouri Richins money?
There was a need for that loan. There was a need for that money to make sure that financial things were going to happen for reimbursement.
And was that related to a Kouri Richins Realty project on Franson Lane?
Yes.
And was that in October of 2020?
Yes. I believe so.
And was that approximately
In October 2020 was the same time that Eric found out about the HELOC, and then he consulted a divorce attorney, and then he had his trust, the will, all redone because he didn't trust Kouri anymore.
$200,000?
Approximately.
Before we get into the next sidebar, Miss Nestor is cross-examining Cody right now on the stand, and she's getting to the part where she talks about what the company was worth. How much was Eric making? Something that we already covered in our last sidebar the day before. However, there's a reason why Miss Nestor is getting into this. The court. What difference does it make how much money this gentleman made in 2022? Miss Nestor. Because that's what Eric made, and how much Eric gets cut off by the judge. Well, he didn't because he died on March 5. Miss Nestor, how much Eric was making this time, it goes directly to rebut their motive that she would kill him for money that's less than what he would make. Inaudible. The court. So how are you going to link what Eric would have made to what would have flowed to Kouri Richins? They're married. He could have given her all of it, none of it, some of it. The jury's allowed to take that into consideration. Well, that would be pure speculation. I think he says a lot to the defense so many times in sidebar. Ms. Nestor. So is their motive theory? It's pure speculation. I have a right to rebut it. No, their motive theory is based upon the prenuptial agreement and... Miss Nestor interrupts, Your Honor, if you're not going to let me get in about what her husband made when they're saying she killed him for money and he made way more than she ever got in the life insurance money, you're not answering the question I have, though. And so if you have an answer, need to know it. How are you going to link? Just tell me, how are you going to link for the jury? The money would have been available to Kouri Richins. Yeah, I don't know. Based on the actions that Eric was taking, I don't think he was going to give that money to Kouri. Maybe to his kids, but to Kouri, it's a different story. Because they have a joint checking account. His salary went into the joint checking account, and Brooke has already testified to that. Brooke is a forensic accountant, by the way. Okay. How many other questions do you have down this line? Just the value of the company, and that's it. Yeah, that's even harder. She doesn't have an interest in the company. That's right, she doesn't. It's 50-50 with Cody and with Eric. Kouri. Ms. Nestor, well, but he does. He has a bias of why would testify this way. I don't understand that part. I understand your point regarding his income, and I'll allow you to get to that answer. Okay. The value of the company, though, I don't understand that. Well, the value of the company had Eric live. Had she not done whatever they said she did, you mean murder, she stood to gain way more from what he would have taken on draws in the future. That's where I'm generally lost. I see no evidence that that's true as a matter of the law. All of the money went to their joint account. Yeah, but that's not the value of the company. No, but the company, if he ever sold the company, she'd be entitled to get that. But there was no evidence that he intended to sell the company. I can't give you that. That's too far afield. So what is the grounds for refusing to let me do that? Because you have no non-speculative link between the value of the company and the money would have flowed to Kouri Richins under the facts of the case. All right. So Ms. Nestor is saying that, well, if they're going to accuse Kouri of murdering her husband, why would Kouri murder her husband when over the lifetime, the money in the company would have generated way more money than what she got in the life insurance policy? That's one thing. And then additionally, to address that, well, they have a joint checking account. Yes, if Eric stole the money, the proceeds could have gone to the joint checking account, or Eric could have put it in a different checking account that maybe Kouri didn't have access to. That's the reason why she's trying to get out to the jury that, oh, this is how much the company was worth. Eric made a lot of money. Why would Kouri want to kill her cash cow? Well, as we learned from this trial, Kouri was not the smartest person. She was really greedy and she wanted to do everything herself. You know, after she got rid of Eric, she wanted to continue with her real estate company, making money, flipping houses and all that stuff. But because she was in so much debt, it seems like she had to murder her husband in order to surface her massive amount of debt, and she can run away forever with Josh Grossman and live happily ever after. But then that even happened because they ended up breaking like 8 months later. Oh, Jesus, Kouri.
Do you know what Eric made in 2021?
Mr. Bloodworth, go ahead.
Objection, foundation.
It's a yes or no question, so if you would start there, sir. Overruled.
Do you know what Eric made in 2021?
No, not off the top of my head.
All right. So if there's tax returns that have already come in that indicate, that came in through an expert, that indicate he declared around between $700,000 and $900,000, would that be way off base for that year?
If you pause there for a moment, Mr. Bloodworth.
Objection, foundation.
And you approach for a minute.
Oops, sorry, I just realized I didn't have this size correctly. Okay, it is sort of fixed now. Sorry about that. For losing guys were like, oh my God, it's been uneven. My bad. Sidebar. The court. Did any such tax return come in? Miss Nestor. Uh-huh. Through Brooke, forensic accountant. Can you point me to it? Uh-huh. Mr. Bloodworth. I don't think inaudible. I think Brooke testified to the 2019 tax return that the defendant forged. Inaudible submitted to the repayment of the PPP loan. The court. I don't think the 2020 or 2021 tax returns came in. Miss Nestor. His K1 came in. The court. Well, that's not the tax return. Well, it's his K1, which shows what he made. Well, it shows what the company distributed to him in total, right? Right? Correct. As non-W-2 income, right? Okay, that's a different question. Well, I'm not a tax accountant, but yes, but you're an attorney, and this is your, this is the case that you're working on, and you should be familiar with the exhibits, right? The court. Well, we've got to be precise here. We're going to make a hypothetical. Okay, but did that in fact get admitted? I'll move on. Okay, Mr. Bloodworth, I don't think it got admitted. Okay, all right. And then they continue in open court.
Did you, at the time that Eric died, did you project that your company was going to continue to increase in value and resulting in increased income to both of you over the years?
Before he passed, you're
Yes.
asking? Yes, we would have projected that our company would continue to grow.
Right. And fair to say that you both would be financially secure as long as that continued to happen?
As long as that continued to happen, yes.
All right.
So what do you think? Do you think the defense did a good job of bringing it up to the jury that, oh man, Kouri would never kill Eric. Eric was going to make so much more money. Financially, it just doesn't make sense for her to do so because Eric was the one that was supporting the household. And look how much money he was making. What do you think?
On the day that you spoke to Eric Richins on Valentine's Day, you weren't aware that he went to a doctor that day? Did you ever know of him going to the doctor, taking time off?
He told me that he had gone with Carter that morning.
To get allergy shots?
Something with allergies.
Okay. But after you spoke to him, were you ever aware that he went to a doctor to follow up on how he felt that day?
Your Honor, objection calls, I think, for hearsay. There's no foundation otherwise.
If he had personal knowledge, if Eric took time off to go to the doctor?
Please approach.
And again, the defense is really trying to downplay this Valentine's Day attempted poisoning, that it wasn't Kouri that tried to poison Eric. It was Eric getting food poisoning for leaving that darn gosh egg sandwich in his car for 2 hours and waiting to eating it later on. And it probably had mayonnaise in it. Yeah, and it was probably a soft-boiled egg. Anyways, let's get into the sidebar. The court. The only way he would know is if somebody told him, specifically Eric. Ms. Nestor. Well, if Eric put it in for time off, he could know that. I mean, if for sick leave, he said he was going to, but the only way he'd know that is if Eric told him. If he visited him, if he gave him a ride, if he took him to the hospital, but asked those questions, I will. Okay. So she does ask Eric, or she does ask Cody those questions like, oh, did you give Eric to the ride to the doctor that day? Did you give him a ride to the hospital? Did you go visit him in the hospital that day? He's like, no. And it's like, okay, well, like when Eric was calling you, did you hear any ambulances in the background noise? And he's like, nope. But you know what? It doesn't mean that Eric didn't feel very sick that day. The fact that digital forensics showed that Eric was always on his phone, always moving around, especially during his workday, and that for some reason during this day and during a time period, Eric was knocked out for, was it like 2 hours or something like that? So that in conjunction with some of the testimonies from, I mean, although they're very vague, but from family members and friends saying that like, yeah, Eric called me. He sounded kind of scared, seemed like he wasn't well. And that all goes to that maybe Eric really was feeling really sick because possible fentanyl poisoning. And also Carmen's testimony that Kouri had procured fentanyl days before this. And when that didn't work, she asked Carmen for the stronger stuff.
You testified that generally people had told you that Eric did drugs. I want to be specific. Did people generally tell you that Eric would use THC edibles?
Object to hearsay.
You open the door, overruled.
Can you repeat that?
Did people
And when she opened the door, dude, she did it with so much sass.
tell you that Eric would use THC edibles?
People would tell me that, yes.
Did anyone ever tell you that Eric Richins used illicit street drugs?
No.
After the direct examination of Cody, there is a sidebar that happens. So Miss Nestor says, Your Honor, Mr. Bloodworth just asked this witness if anyone's ever told Eric that if anyone's ever told him that Eric used illicit drugs. He said no. Okay. In the prelim, he testified that he was aware that Eric used illicit drugs in high school. I believe that door is open. I know you wrote on that, but I think the door has been open. I can impeach him on that statement. Do you have a copy of it? I do. Would you like to see it? Yep. Yes. So instead of having the jury wait there, the judge is like, hey guys, clear out, please rise to the jury, everyone go, and then we'll have a chat on camera, which I really do appreciate. We're going to be jumping around here because it is a very, very long side quest that they go through. But essentially, during preliminary hearing, Cody Wright had testified about Eric using pain pills back in high school. And so the defense wants to bring that in and use it against him. They weren't allowed to based on motion in limine. However, Ms. Nestor's arguing that, well, it seems like Mr. Bloodworth opened the door and now I can impeach him with his testimony at preliminary. However, there is a difference between illicit street drugs and abusing pain pills or abusing medication. There's a back and forth with the judge and Ms. Nestor, and it starts getting really spicy.
In this testimony at the preliminary, page 16 line, beginning at line 15, and were you aware that in high school Eric had an addiction to pain pills? Answer, I did know that he participated in pain pill taking for sure. Question, you did? Answer, yes.
Oh, that's right. Okay, so the defense wants to bring in that Eric abused prescription pain pills back in high school, so like 20 years before. And so I think initially the judge was not going to allow that in, but he was going to wait until what kind of testimony they were going to get out of Cody. So I think the defense is trying to say that like, oh, we kind of did ask about if Eric used drugs and then he said no, but then let's look at this testimony that he gave prior and it's inconsistent. So they'll probably bring Cody back.
And do you know what his pill of choice was that he was addicted to back then? Answer, I believe in high school we called them Red Devils.
The what?
Is that where you want to stop?
Yes.
Okay.
The Red Devils? The Red Devils? I've never heard of that before. Is that a Utah thing?
I'm not entirely sure that Mr. Wright is referring to illicit street drugs, quote unquote, there, but I also don't know the other way. So the ruling was that I deferred ruling on the motion in limine until after the parties have an opportunity to voir dire witness Cody Wright or provide other evidence outside the presence of the jury to determine whether there is any non-hearsay route to the admissibility of the proposed evidence.
Thank you, Your Honor. So here's what just happened. Mr. Bloodworth asked the question, has anyone ever told you that Eric used illicit drugs?
Street drugs.
I objected to hearsay. The court ruled that I had opened the door and allowed him to elicit that hearsay evidence.
Yeah, in fairness, you're skipping the first step.
Yeah, the state asked, did Eric use edibles? Said yes. Then she objected, and the judge was like, you opened the door. Then the state asked, did Eric use illicit drugs? No.
You opened the door and crossed this topic.
I just said that.
Right, but I want to be clear.
Okay.
It's not just an allegation that you did. You did.
Okay.
Then Mr. Bloodworth went into it.
Okay, absolutely. I was trying to convey that. I'm sorry if I didn't do it correctly. I was not trying to skip any step. You ruled that I had opened the door. You allowed him to elicit what would typically be hearsay evidence because I had opened the door. Now it's in. Now this witness has said on the stand, no one's ever told him that Eric used illicit drugs, and that is not true.
Illicit street drugs. Please be precise.
That's what these are. He's claiming.
Well, we don't.
If the court keeps reading to the top of page 61, Cody Wright says he has no idea what Red Devils were.
He says prior to that he is very aware that Eric took pain pills in high school. He says that clear as day.
Why don't we just ask him what he knows?
We can, but
Oh, you don't want that. You want to just use this.
I want to use this, and I want to do it in front of the jury. I don't want to give a chance.
You don't want to just put it in. You want to ask him questions about it, right?
No, I just want to use, I want to impeach him with this document only.
You don't have any foundation that red devils are illicit street drugs, though, so you need that foundation
Pain
for
pills
this.
would be.
But that's not illicit street drugs, and that wasn't the question. This is an important difference. Nobody's asked this gentleman
Your Honor,
or shown that
if you buy pain pills,
please
I'm
don't
sorry.
speak
I'm
over
sorry.
me
I'm
so
sorry.
that you have a clean record.
Yes, sir, I'm sorry. So, my understanding, according to this, is that Mr. Wright doesn't know what red devils are, but that's what they called them in high school,
Seems accurate.
which is clearly saying these were not doctor prescribed, these are illicit drugs that he's using in high school. So,
No, there's a
How is that clearly saying? If you're saying that he didn't know what they were, how is that clearly saying?
there's some distance between a nickname called Red Devils and illicit street drugs. I mean, I don't know what the Red Devils he's referring to are, but it doesn't automatically mean they're illicit street drugs.
if you use pain pills without a prescription, that is illicit street drugs.
It is not, and you know that to be true.
I disagree, Your Honor.
It might be diversion of a prescribed substance, but it's not illicit street drugs.
They've certainly heard testimony from Mr. Crozier that he's selling oxycodone on the street that came from prescriptions. That's illicit street drugs.
I'm not sure you want to take that position going forward, but I don't endorse it in any respect. Certainly, we know that diversion of prescribed legal medication is different than purchasing on the street prescription medication is different than purchasing non-FDA approved substances on the street. There is a range of conduct here, and the question asked by Mr. Bloodworth was specific.
So now they are going to voir dire Cody Wright outside the jury presence just to see what does he know.
Was it your understanding in high school when you had this knowledge that Mr. Richins was using these drugs illicitly? In other words, not with the prescription of a pharmacist?
I need you to be more precise in that question. Which drugs are you referring to?
The pain pills, sorry.
And if you would re-ask it, please.
Was it your understanding in high school when you knew about this that Mr. Richins was using his own prescription for pain pills or someone else's?
I learned about this later on in life, not in high school.
Okay, and what did you learn?
And I learned that he had taken pain pills in high school. That's what I had been told.
Without a prescription?
I didn't get asked whether there was a prescription or not. I don't know.
All right, and then I think you said in the prelim that you thought they were called Red Devils, is that right?
That's what I was told.
And was it your understanding that Red Devils were an illicit street drug?
I don't know what an illicit street drug entails, but I assumed that the Red Devils were being abused as that's what high school kids were doing.
So people were doing that in your school?
I heard that, yes.
And did you know what Red
Later
Devils...
on in life.
What, did you know what Red Devils were?
I learned later on what those were, yes.
What are those?
I believe it's Sudafed.
Oh, it's Sudafed?
I think. I'm not a drug person. I'm sorry.
Okay. Could be pseudoephedrine, maybe.
I have no idea.
Okay.
But that's what I think it is Sudafed being abused.
Okay. Well, Your Honor, I mean, I think that this witness has now clarified that if he were to answer the question now, he would include that he was aware Eric popped pills in high school. He also heard that people in his high school were doing Red Devils. He said he assumed that's what Eric was doing, but he doesn't know. But he has knowledge that Eric was popping pills. This whole case is about a pill addiction. This whole case is about whether or not Eric Richins voluntarily ingested that or if he was given it by his wife. This is a critical piece of the defense.
Your Honor, the state disagrees with all of that, including the veracity of some of that. The state reverts back to what we had briefed in motion hearing, by the way, that any relevancy to what happened in high school has decayed to zero 40 or 20 plus years later.
His prior reference to Red Devils, he's now clarified as Sudafed, which is not pain pills to begin with. Moreover, he doesn't have any admissible testimony that Eric Richins used illicit drugs of any kind. This is hearsay. It is speculation. It's not admissible.
Your Honor, may I just make a record?
Of course.
Your Honor, it's our position that, first of all, when I asked the question, it was not objected to by the state. Second of all, I'd like to make the record that this would be for purposes of impeachment. To deny us this opportunity is a violation of Crawford. It is a violation of our Sixth Amendment right to cross-examine. It is a violation of our due process right to a fair trial. We would be able to call, in our case, an expert who would testify that Red Devils were, in fact, PCP in that period of time. They were not Sudafed. The DEA has a pamphlet on that. We're being denied that option. We're being denied the ability to attack the
Wait, we're going to PCP now?
credibility of someone who has changed. Respectfully, we disagree with Your Honor's position on this. We think he absolutely changed his testimony, and we're being prohibited the right to impeach him on the fact he changed his testimony. And I believe that the question I would ask him, if I were allowed to go forward, would be, did you learn that Eric popped pills in high school? And that would impeach what he said to Mr. Bloodworth, unrebutted and not allowed to be rebutted by me when we know that I can rebut it. And we, in our strongest way possible, we object to this. We would like a continuing objection. We move to strike all of Cody Wright's testimony, all of the issues that Mr.
You lost me there.
On redirect, the redirect testimony.
Which piece?
Where he answered the question that I'm not now being allowed to impeach him on. We're asking to strike it at the very minimum. All of the things that Mr. Bloodworth just brought up all go to weight, not admissibility. And
what is the non-hearsay route for this witness to testify regarding what he heard, if it's coming in for the truth of the matter asserted?
It's not. It's coming in to impeach that once the court allowed him to answer that question with hearsay, to rebut the hearsay that we elicited unintentionally.
What's the evidence that he heard prior to today, testifying today, that Eric Richins used illicit street drugs?
He just testified to it on the stand.
That is not true.
Okay, well, we agree to disagree on that, Your Honor.
Have you disclosed that expert that would provide a non-speculative basis that Red Devils are an illicit street drug?
We have disclosed that expert. His name is Mr. Kearney. He is on our list. He's been available. We did not know the Red Devil stuff was coming in until 10 minutes ago because we were told.
Coming in.
Well, okay. Well, that's obvious then. I mean, we did the best we could. We gave him our drug expert that as soon as the Red Devils comes in, we can let them talk to him about that because we sure would go into that with our expert. That we're now being denied the ability to do that. There is a key question here, Your Honor. If Eric Richins had a drug problem, and if he did, Ms. Richins is innocent, and we are being prohibited from going into that with the one person who knows. And I just think that the veracity of this witness on this topic cannot be underestimated for purposes of the defense. I know you disagree with us. I believe I've made my record. Yes. He's changed his story. He's now saying he's never heard that Eric used drugs when he knows in the prelim that he did.
What?
And I just think this is just a huge, huge impediment to us to put on a fair trial in this case. And I believe I've made my record. I can't think of anything else I need to say on the record. Thank you for letting me make a proffer.
Okay. Are you asking me to strike Mr. Wright's answer that he's never heard that Eric used illicit street drugs?
Yes.
On which basis? On what basis?
On the fact I'm not allowed to impeach him on it, and we all know it's not a correct answer.
You certainly can impeach him on it if you have any evidence that it's impeachable.
No, any other way to show it to the court other than what we've already done.
Okay. I want to be clear. There's just no evidence that Cody Wright believes that Red Devils are illicit street drugs.
But he separated the Red Devils from the popping pills. He separated that.
No, with
did?
respect, he didn't. But
Okay, well, I think the transcript will reflect it.
All right. Let me pause. Anything further? I'm not persuaded that you've provided a basis to strike Mr. Wright's statement that he's never been told that Eric Richins used illicit street drugs.
I understand your ruling.
Throckmorton is now testifying. I love that. Stay with Throckmorton. Mr. Throckmorton was the one that compared the signatures to figure out whether or not Eric was the one that signed the True State life insurance policy. He was like, no, it seems like it could have been someone else, but he couldn't identify that it was Kouri who did it. Now let's see what happens in during this testimony. Oh yeah, something about blind verification here. Say, okay, let's get there. Oh, you know what? I accidentally skipped through this in the live stream, but Miss Nestor is asking questions about. Is Miss Nestor, right? No, sorry, Mr. Bloodworth. Mr. Bloodworth is still doing direct examination of Throckmorton, and Throckmorton sends this analysis that he did over to Oh, am I just getting hungry? Maybe I am. He sends out the analysis that he did to it was like a blind verification to his friend in Colorado to see if she came to the same conclusion. And then this is where Nestor objects to hearsay, and now they are in sidebar. All right, Mr. Burmeister. All I asked was a yes or no question. The court Well, yeah, but he was about to say what the verification was. Mr. Burmeister, okay, I'll move on. Court says, thank you. I appreciate it because, you're not allowed to have the hearsay come in, because it seems like where Throckmorton was about to go to was that she was the one who told him X, Y, and Z, which is, oh yeah, I had the same conclusion as you did. So that's why they're not allowing it in.
That is what you have reported with your training and your opinions, your expert opinions, that Eric probably did not sign that true stage document.
There was no evidence he signed it.
And you cannot say that Kouri did sign it, right?
That's correct.
Okay. Now, by saying that, you have no personal knowledge whether Kouri Richins was given permission by Eric to sign his name.
Objection.
Sure.
In the sidebar, Mr. Burmeister, this goes beyond the scope of direct. He has no basis for the court. That's exactly what she's asking. He's going to say yes or no, and then we'll move on. Very short sidebar.
So just to repeat the question, you have no knowledge and you weren't given any information to suggest one way or another whether Kouri had permission to sign her husband's name to that.
Correct.
You don't know that.
I was not asked that, and that was not part of the examination.
And I see you're a married man.
Yes.
On your wedding ring.
Yep.
And does your wife ever sign your name on anything?
Objection.
I think we're a little bit beyond the scope of this gentleman's expert testimony. Go ahead. What's your next question? Sustain.
Oh my gosh, I forgot about this part of the cross-examination. You guys let me know what your thoughts were when you were watching this in the live stream. It was one of those moments where I was like, oh, ooh, oh. Am I ruining it for you guys right now?
And is it my understanding from your resume that you no longer do forensic document examinations for the Salt Lake City Police Department?
That's correct.
And when did you stop doing that?
2020, I believe.
Right. And is that the reason you stopped connected at all to an internal affairs investigation against you for falsifying documents?
No.
Okay. Did you, in fact, were you submitted to an internal affairs investigation for falsifying documents?
Objection, Your Honor. Can we approach, please?
Sure.
What? You see, when I heard about that, I was like, ooh, what is going on with this expert? Sidebar, Mr. Burmeister. This is based on, Miss Nestor. Here, can you, Mr. Burmeister, this is based on a false accusation retaliation by some officer who's been since fired from Salt Lake PD. The court, now we're opening it. You'll be allowed to elicit a testimony, certainly. Mr. Burmeister says something inaudible. For some reason, the state has issues with reaching their microphone, or maybe there's only one microphone when they're speaking to the judge, maybe, and it's hard to speak into it together with the state and the defense attorney, possibly. So now let's go back to open court to really, Remy says hi, by the way, to see what went down. Why was this guy accused of falsifying records? Huh?
I need you to restate the question.
Yes, sir, Your Honor. Were you subjected to an internal affairs investigation for falsifying documents?
Yes.
All right. And were you ultimately exonerated?
Yes.
So you knew that he was exonerated. Then why bring it up? I felt like it was a nothing burger. Like you're teasing us, and then it's like, oh, it's not a big deal. Oh, the defense.
And was the person who accused you of doing that a law enforcement officer?
He was a retired sergeant who'd been hired back as a supervisor, who was then terminated for a number of issues.
So you were falsely accused by a law enforcement officer?
I was falsely accused by somebody who had been a law enforcement officer, but not at the time they made the complaint.
Poor Miss Nestor. Her throat is giving out. There's, what are we on, day 9, day 10 for the court right now? Oh, man. Now, when we hear about this My Princess letter, I'm like, what the hell is this My Princess letter? Is that what Eric called Kouri? Yeah, I think in his phone, actually, when we go through the text messages, Kouri is saved as My Princess in his phone for Eric.
Looking at the documents that you relied upon, was one of the documents titled the My Princess letter?
I did review that, yes.
What?
Right. And what was that?
Oh, did Eric write a letter? Apparently, My Princess is what Eric had for Kouri in his phone.
It was a few pages of writing purportedly written by Kouri.
By Kouri?
Or sorry, no, by Eric. I apologize.
Where did you get that letter?
This exceeds the scope, Your Honor. That is not in 849.
Your Honor, I'm allowed to go to anything he looked at to form his opinion.
Yeah, I just need clarification for a second, if you would.
The court responds to Miss Nestor and says, that's true. He did give a general answer. Is this the only document he's examining in this case, the true stage? Oh, sorry. He was talking to Mr. Burmeister. Mr. Burmeister says, true stage. Yep. The court. Oh, man. Sorry. My notification's still loud. Let me turn that off real quick. Okay. The court, he testified that he relied on the 200 pages in forming an opinion. Wow, 200 pages. Mr. Burmeister, yeah, but the inaudible, Miss Nestor. And that's my point. I'm getting into that. The court, oh, well, if he didn't rely on it, then Miss Nestor, he did rely on it. He chose not to include it in his report. You two were saying two different things. So would you lay a little foundation? She says, yes. Miss Nestor says, yes. For whether. The court says, hold on. I'm sorry. Just so I don't have you make you do this again. I apologize. Miss Nestor, it's okay. The court, it's unclear to me whether the document you're currently discussing with him was among the 200 pages that he did review or not. Miss Nestor says he did review it. He chose not to include it in his report. The court, I'm telling you that that's unclear. Miss Nestor, I'll clarify from the testimony. Right. So she's going to clarify. And guess what? Well, he did review it. It wasn't included in the report, but he reviewed it after he had written the report, it seems.
On the My Princess letter, that is something law enforcement gave to you to review in making your opinions, correct?
It was given to me as a question document, not a known sample.
And you were to review it to see who you think wrote it?
That's correct.
Another sidebar is going to follow that. The court says, so if it was given to him as a question document rather than a known sample, a Q rather than a K, his testimony so far is that he would not rely upon it to form his opinion regarding the true stage application as a Q document. Miss Nestor, well, from my understanding is that he did both, and I can try to clarify that if you would. Okay, now here she is going to try to clarify.
When you were looking at the Eric Richins handwriting samples to compare them with the true stage signature, had you also already reviewed this document?
No.
This came after?
Correct.
Oh, okay. Okay.
If I remember correctly, I don't think we ever saw the Wright Princess letter. I'm nosy. I wanted to read it so bad. It seems like the defense wanted it to come in and, maybe the state was pushing back a little bit. But, man, what do you think the letter said? If I remember correctly, I don't think we ever saw the Wright Princess letter. I'm nosy. I wanted to read it so bad. It seems like the defense wanted it to come in and, maybe the state was pushing back a little bit. But, man, what do you think the letter said?
When you arrived at the Richins home, what did you first encounter?
I ran into his sister at the bottom of the driveway. I spoke to her briefly. I went in and spoke to the initial officer that was on scene, and I did interview some of the witnesses there.
When you met with the sister in the driveway, do you remember which sister?
Amy.
Did what she told you inform you how you approached what you did once you entered the house?
Yes.
What did she inform you?
Your Honor, can we approach?
Of course.
I think this is going to be a long sidebar. All right, let's get ready. Ms. Nestor. So according to the Officer Woody's report in the discovery, Amy made allegations that Kouri had threatened him. She made allegations that she tried to poison him before. I'm not positive about that, but I know she said that she threatened him. She tried to poison him before, that she had recently found out about the trust and had threatened Eric about it. All of these things are, first of all, 404B. Second of all, hearsay. I think that Mr. Bloodworth can get where he wants without getting those specific statements in. 404B, was that like the prior bad acts character and stuff like that? I think it is. Let me look it up really quickly. You'd think I would have this memorized by now, but there's so many rules. Utah. Yeah, crimes, wrongs, and other acts. So Miss Nestor is objecting based on two reasons. The court. What are you expecting detective is about to say? Mr. Bloodworth, I expect that she'll say that my brother had told us, meaning his family, that if anything happens to him, it was probably Kouri. Miss Nestor, that's clearly being used for the truth here. You know what? Where's Miss Lewis? Do we not see Miss Lewis at all today? Man, we kind of miss Miss Lewis. The court, well, he laid foundation for it to not. The question is, do you want me to specifically, let's assume it comes in just like that, and then they move on. Do you want me to instruct the jury that you cannot consider that for the truth, only to inform or explain what Detective Woody did next? Ms. Nestor, why, I just don't know how you could unring, what is happening? Ms. Nestor, well, why, I just don't understand. He's being a little sassy. I don't think you guys can hear him. Get your own ball. Why, I just don't know how you can unring that bell, right? The court. Well, the difficulty, though, is if the defense is going to, at any point in the case, suggest that law enforcement latched on to Kouri Richins without any basis, we have to let them some minimally prejudicial version of that explanation come in. Ms. Nestor, under Rule 106, I want everything she said in. So if I remember correctly, I think 106 is the rule of completeness. If you let in over my objection, I would like the entire thing she told her to come in, including that Kouri knew about the trust and that she was upset about it. Now, guys, let's pause a little bit here for a second. And Remy, I can hear you over there, Remy. Let's pause. So we all believe that Kouri found out about the trust after Eric passed away, when she was trying to get into the safe and one of the sisters broke the news to her. And that's why Kouri went into, she saw blackness, or what is it? You see red or you see black? You see red, right? Yeah, you see red. And she went and started like attacking the sister and punching her. However, what Miss Nestor is saying is that, well, Kouri found out about the trust before and that she threatened to kill Eric or something happened. So I think where Miss Nestor is trying to say that she already knew that she wasn't a beneficiary of the trust. Therefore, why would Kouri want to murder Eric? It seems like the motive that the state is pushing out there is moot. However, I don't think that's a version that actually went down based on what we've seen so far. Now, the court, though, was like, I don't know if you want to go down that route. Because, technically, if Kouri was pissed that she wasn't a beneficiary of the trust, what if she was so pissed that she did kill him and that she did go through with her threat? Either way, it makes Kouri look really bad. Now, let's go back to the sidebar. The judge is like, okay, I want to think very careful about that because I don't know what the other door opens. Do we need to have a conversation about what it's going to look like before you do that? He's like, I want you guys to be very careful. Mr. Bloodworth, I think the trust bit is different. That was Katie, not Amy. That was Katie later on that morning. Miss Nestor, well, I think the court, all I'm saying is that I take what you said seriously, but maybe makes sense. If we're going to go that way, to allow us to hear what this witness is going to say about what Amy said to her in that moment, Miss Nestor's like, oh, a quick voir dire? The court's like, so you know what you're, yeah, that's fine. So I think, are they going to do a voir dire? The court, you know what you're agreeing to because I haven't heard it. Miss Nestor, yeah, any objections? No objections. So they excuse the jury and they are going to do the voir dire to see what it was that Detective Woody heard from the sister. I think I have this footage, yes.
When Amy met you in the driveway, did she say anything that informed your investigation?
Yes.
What did she say?
She told me that Eric had said to her that he thought Kouri was going to kill him.
Then did you go into the house?
Yes, I did.
So in your report, when you reported what happened, you said Amy said she thought I should know that Eric and his wife Kouri were having problems and that Kouri had threatened him.
Yes. Threatened to kill him. Yes.
Okay, that's different than what you just said. So that's what you were referring to?
Yes.
All right. Then you walked in the home and then you came back out and had another conversation with Amy and her other sister, right?
Yes.
All right. And can you explain, just because we're going to get into this in a minute, what they told you on that second conversation?
I'm trying to remember. They said they had been fighting a lot and that Kouri was erratic when she was drinking and that Eric had told them that she had threatened to kill him.
Jeez.
And did Amy tell you that Kouri found out recently she wasn't the beneficiary anymore and that because of that she threatened to kill Eric?
She told me that at some point, but I can't remember when.
Okay.
After, I think.
So she told you that Kouri had found out he had basically made her not a beneficiary?
At some point, yeah.
Before he died?
She said that at some point, but I don't remember when she told me that.
Okay. And what about that statement changed the way you behaved when you went into the house? Because I think that's the question he was asking you.
It just made us look at it with a more critical eye.
Now, the other aspect that the defense is getting at was law enforcement was already tainted by what Eric's family had told them, and therefore they just zoomed in on Kouri and already thought she was a suspect from the beginning and found evidence that supported that theory. That's what they're getting at here. Now we're back in sidebar. The court's like, so we're staying focused on the first conversation in the driveway, right? Miss Nestor, right, for now. The court, yeah. Miss Nestor, I'm sure she's going to get into the second one. That's why I did it now. Maybe, maybe not, but we're not there yet. So now that you've had an opportunity to voir dire Detective Woody regarding the first conversation, which way do you want to go? More or less information? Miss Nestor, so I don't think the statement should come in. I think it's clearly 404B. I think you can get the same information about, did she give you information that made you suspicious that this was not a natural death without saying the statement, which is wholly prejudicial. And for clear 404B, we did not get notice they were going to introduce that statement. Oh, we're going to have some arguments here. The judge, it's not, well, I understand. The difficulty here, though, is that would mean that you wouldn't be able to open the door to it by suggesting that the state inappropriately or without foundation focus their investigation on Kouri Richins. Well, I think she can say that what Amy had told her made her suspicious. This may not been a natural death without saying that there's an allegation that she threatened to kill him on another occasion. But you're not engaging with my question or concern. You know what? I feel like that's such a good line to be using on kids or like someone that you might be having an argument with. And they're just like arguing above you, you know, and they're not really addressing what you're trying to get at. So I like that line. Judge, I'm going to steal that. Miss Nestor says she's trying to. The court, it's not an unexplained, unattended death. It is Kouri Richins as a cause that Miss Nestor interrupts. She could even say that whatever Amy said made her suspicious that Kouri was involved. I wouldn't object to that. I do object to the statement coming in that on a previous occasion, she threatened to kill her husband because that's a crime, not a 404B. And we don't have advance notice of that. The court, you've had ton of advance notice of it. Oh, man, where are we going with this? Miss Nestor, not that they were going to introduce that statement. They're supposed to give me written notice under 404B if they're going to do that, and they have not. Well, hold on. We're moving around here. It's hard for me to follow your argument here. So is your argument that it's hearsay? Miss Nestor is like, yeah, hearsay is one, the court, but it's not coming in for the truth, so that's overruled. Boom. Okay, shut down with that one. However, Miss Nestor might have something here with the second one. Then the second is 403 and 404B. And no previous notice that they were going to introduce this 404B that she threatened to kill her husband on another occasion. I don't even know what occasion. Well, but she said, the conduct that you had ample notice of, we've been litigating it for months. Miss Nestor's arguing back, and she's like, but that's not if they're going to bring in 404B, there's a rule. They have to give me written notice. Miss Nestor, yes. We've been litigating the admissibility of evidence regarding her attempt to kill her husband pursuant to count 2 for 2 months. So Miss Nestor's like, I don't think they're talking about February 14th. So now the judge is like, oh, well, what the fuck are they talking about? I don't know what they're talking about because we're not Amy. Well, we have the extent of the statement, so it's Miss Nestor. Okay, can I stop you there to make my record? I totally respect what you're saying. February 14th, it's my understanding that there was never a threat made by Kouri that's connected to February 14th. They think she took action against him, but there's never been any suggestions that she made a threat. Oh, I see what you're saying. Okay. So it's been another occasion so that it's clear 404B. It does require prior notice, and it's also highly prejudicial. And it's not necessarily to get the information that he wants, which is whatever Amy informed her led to believe immediately Kouri was a suspect. I wouldn't object to that. All right, Mr. Bloodworth. Mr. Bloodworth is like, so if I phrase a question, something like, did what Amy say to you suggest that Kouri Richins, Miss Nestor gets in, could have been involved? Could have been involved. That's fine. Okay, maybe proceed with that. Okay, sounds good. Detective Woody is still testifying on the stand. Now, the state is going to ask about the gummies and whether or not they were tested for THC. And then we get into a very long sidebar, which I will continue after I make my dinner, feed my dog. And you know what? We'll just do the rest of this tomorrow. But I'm going to wear the exact same outfit. So it looks like it's the same day. My hair will probably look better, though, because my hair usually is like really flat on day 1. But on day 2, 3, and 4, it's like more voluminous. All right, guys. I will see you guys in 2 seconds, but it'll be tomorrow. Just kidding, guys. You're only getting my voice today. All right, let's listen to Jamie Woody's testimony.
Did you seize any THC products?
Yes.
The gummies. The gummies.
On May the 2nd, 2022, did investigators send those THC products to the state crime lab for testing?
Yes.
Yep, see if there's any fentanyl in there.
On March the 4th, 2023, did Brian Holden from the state crime lab send investigators the test results?
Yes.
And did
That
those test
long?
results confirm that there was no fentanyl in those THC products?
Objection. Can we approach?
And in sidebar, starting off with Miss Nestor. We agreed to stay away from this, but he just opened the door. That is not an accurate statement. The test results said that there was a presumptive positive fentanyl in the THC gummies. We agreed. Gets cut off by the court. I thought the presumptive positive for the fentanyl was on the baggie that was located in the jacket pocket. Am I wrong about that? No, but also in the THC gummies, we had an understanding we were going to leave that alone. He just made false statement. They showed no fentanyl, which is not true. I think I can rebut it now. Mr. Bloodworth, that's 100% misstates a statement. What was the agreement? The agreement was because presumptuous tests are unreliable, we can only refer to confirmatory, and the confirmatory tests do not show any fentanyl. Miss Nestor, they didn't do a second... What the hell is working? They didn't do a second confirmatory test on the gummies, the court, because we have evidence that came in that said we don't do confirmatory tests on that are below presumptives that are below a certain level, right? That's right. Correct. Right. Okay. So the question is, did that testing confirm? And the answer is no. Miss Nestor, Mr. Bloodworth continues, it's the same thing that Brian Holden testified to. He already testified to this. Yeah, Miss Nestor, you just asked her, did the test come back that there was no fentanyl in the gummies? And that's not true. The court, well, wait a minute. No. I mean, he's reading off a piece of paper, so I think his memory is correct regarding did the test confirm? Miss Nestor, that wasn't the question. Mr. Bloodworth, do you want me to re-ask the question? The court, if we can clarify, and ask him, did any test confirm THC in a gummy? Miss Nestor, test confirm because they didn't. My understanding is they didn't do a confirmatory test of the THC gummies, right? But which is why we weren't going to mention any of this. But I mean, right now they have a false thing that I think I'm entitled to correct. So she gets cut off by the court. Why don't we? But isn't the way to address any concern that they are drawing an improper or inaccurate inference just to lay a little more foundation for several confirmation tests were performed? Miss Nestor, I think he should just withdraw the question because otherwise any question about what the test showed is going to leave a false impression to the jury that I think I'm entitled to rebut. I think gets cut off by the judge. What is it you think you're entitled to, though? I am unclear as to what you think you haven't been able to do. Well, he made an argument at the beginning of the trial that a presumptive positive isn't sufficient to, and he cited a case that said that if it is something presumptively positive, right, it's not enough to make it's prejudicial to inaudible. But was a case that said that can't come in, right? Because it's not reliable testimony. Kind of like I think it's like analogous to a portable APBT. Yes, a what? What's a PBT? That's what I just about to say. Yep. A portable, it's a screening test only. Correct. Yep. Miss Nestor. So that's why we're leaving that one alone. We're not going to talk about it, but he can't have it both ways. He can have his cake and say there's no positive fentanyl when there was a presumptive positive of fentanyl on but there wasn't, says Mr. Bloodworth. Ms. Nestor, not presumptive, yet, but presumptive. Mr. Bloodworth, it was an indication. Oh, it was an indication, which is a step below. Indication, presumptive, everyone's talking over each other at this point. Oh my goodness. So it was not presumptive, but it was an indication, which is a step below. Mr. Bloodworth, and it was on material. If we want to get into it, I'm happy to because it's inculpatory to your client. We reached this agreement. Mr. Bloodworth was like, hey, if you want to fight on this, bring it in because it looks bad for your client anyways, but let's go. Ms. Nestor, why don't you just strike it from the question and move on? The court, well, because then it leaves open, I'm imagining, the possibility that they either didn't test the gummies or that we're just not telling them what the test showed. Ms. Nestor, that's true, but that's just not accurate. Right. They did test the gummies, Mr. Bloodworth. Exactly. The court. And there was no confirmed presence of Mr. Bloodworth, right? Ms. Nestor, or indications of. Okay, everyone, can you just like let the judge talk? Stop talking over each other. The court. Yep. Ms. Nestor. It is what it is, but I'm just trying to figure out a way out of this, Morris. It doesn't. Gets cut off by the judge. I mean, for you to respond, you'd have to call an expert, which they don't, by the way, that talks about the difference between indications and whether they're that, and have to get into whether, Ms. Nestor, but that's in my case, the court, yes, and whether the evidence of indications is even admissible. And if it's not, there wouldn't be any relevance to that expert. Ms. Nestor, I'm not trying to back out of the deal. I'm just trying to fix the question. Mr. Bloodworth, I'll ask it more precise. I thought I tried to be very precise, but maybe let me ask it more precise. Mr. Bloodworth, were the gummies sent to the lab? Did the lab tests determine inaudible? Ms. Nestor, were they able to test or confirm? Or were they able to confirm whether or not there was fentanyl? I don't know. I'm trying to think of how to fix it. Give me a second. Were they sent to the lab? Were they able to tell one way or another? No, I don't know. I'm just trying to think. Mr. Bloodworth, aren't we just highlighting it at this point? Well, I mean, I was ready to move on. Miss Nestor, I can't let it sit there now. The court, well, but back to Miss Nestor. I don't want her to answer the question as asked. The court, I don't know that there's any remedy to be had at that moment. The way the question was asked is consistent with the positions the parties have taken so far regarding the admissibility of the indication, and it's consistent with the evidence showing that. Gets cut off by Miss Nestor. How about if he asks her, what if he says, was there an indication? Is an indication inaudible? So they're going to be brainstorming about how to re-ask this question in a little bit. Court, or for a little bit. Court. Well, we'd have to deal with admissibility, and then we'd have to get into expert testimony to prevent them from speculating about what that means. Miss Nestor. His other witness handled this, so it's good if he just withdraws the question. He handled through Holden correctly. He's not handling it through her correctly. So why don't you just, the court, why don't we just move on? Miss Nestor. Yeah, just withdraw the question. If we don't want her to answer it, let's just move on. Mr. Bloodworth. She answered it. The court. Yeah. Miss Nestor. No, she didn't answer. The court. She did. Miss Nestor. I stopped. The court. No, I think she said no. Mr. Bloodworth. I think she answered. The court. Yep. Mr. Bloodworth. Maybe on top of you, but I think she answered. Miss Nestor. Oh, I couldn't hear her from where I was seated. The court. Well, yeah, she said. Miss Nestor. Well, I moved to strike the answer and then just move on. Just say, the court. What do you want to do? Miss Nestor. Don't consider the last question or answer and let's just move on. Mr. Bloodworth. I would like to just move on. I think it's consistent with our agreement. It's consistent with Brian Holden's testimony. Ms. Nestor. I want that answer stricken. I want to be able to go into that's not accurate, so it's either one or the other. The court. Ooh, Miss Nestor getting all fiery up in here. The court. It is accurate, and you don't have an expert to lay. Miss Nestor interrupts. We do. The court. Who is your expert that's going to talk about indications and what that means? Miss Nestor. We can ask Dr. Moss, our toxicologist, but I wasn't going to go into any of that because of our deal. The court. You don't have to do it now. Miss Nestor. Yeah. The court. If we need to have more lengthy conversation about where we're headed in your case, that's fine. Miss Nestor. But if the no stands, it's not an accurate answer. The court. The no is the question, did any test confirm the presence of fentanyl? Miss Nestor. I don't think he said confirm. The court. Do you mind grabbing your notes for me? Yeah, I'm sure he read the question inaudible. He always does. Is that like a little jab that she's taking at him? The court. In fact, we can just rewind Court TV if we wanted to. Isn't it nice to have a live stream of this? That way you could rewind things, I feel like whenever people say rewind, that's like us old school people. I love it. Kids nowadays are like, what the fuck is rewind? Miss Nestor, I know, right? That's such a weird Miss Nestor. Mr. Bloodworth, my notes, I confirm with my notes that it's not inaudible. The court. Okay. If the form of the question is going to inform the relief you're asking for, we can just rewind the Court TV feed and listen to it. Do it. Mr. Bloodworth. I think we just asked the question. Ms. Nestor, yeah, can we just say strike it as ask it answered? Ask it again? The court, okay. They're fixing it. They're going back and forth. But it's already been testified to, fights Mr. Bloodworth. Ms. Nestor, I know, but it's still hearsay. The court, it's already come in. Ms. Nestor, I mean, it's in, but something inaudible. Mr. Bloodworth, did the state lab confirm inaudible? Fentanyl, inaudible. The court, I think that's an appropriate question based on the evidentiary record so far. Ms. Nestor says something that we can't hear. The court, well, why? We don't know if they were able to because they didn't try. We just know that they didn't. Ms. Nestor says something inaudible again. Is it true that they did not run a confirmatory test? The court, that just opens a whole indications bag. Why don't we ask it this way with this witness? And then if your team wants to have a discussion about going into the issues in more scientific detail, we can have that. It just doesn't need to happen right now. Well, here's the thing, Judge. Ms. Nestor ends up not calling any witnesses in their case in chief. They just rested their case. Ms. Nestor, well, my objection stands because I do think that's an inaccurate statement, that is outside of our agreement the way it was asked and answered. The court, well, we're going to strike that and we're going to start over. Ms. Nestor is okay with that. So what's the problem with that question? Okay, so inaudible. Let's do that. I agree to that. Inaudible. The court, why don't we just do this? And I don't mean to open a new can of worms. Why don't we just say, to your knowledge, did the state lab have sufficient evidence of fentanyl in the gummies to run a confirmatory test? Ms. Nestor, oh, that's a good one. I would accept that. Mr. Bloodworth, I don't think she can testify. So now there's this whole other issue where it's like, well, the person that's on the stand right now can't testify to this because they don't know. I think they just have the results. The court, because she doesn't know. Mr. Bloodworth, yeah. Mr. Bloodworth is like, okay, well, what about this question? On March 4th, did Brian Holden from the state's lab send investigators test results? Nestor says something we can't hear. Bloodworth, just from a narrative perspective, it falls short simply because it's the results inaudible investigation, right? And that's the court. No, I understand why the state is asking the question the way it is. I understand why the state lab does what it does. I'm not limiting you from at least proposing a way to bring more detail to this. Nestor, can I ask if he's able to do the confirmation question? Can I ask her on cross, were they able to refute? Were they able to deny the presence of fentanyl? The court, yeah, but the difficulty is when you say able, it would say that there was a lack of ability or scientific basis or data, and they just didn't try. So I'm telling y'all, this was a long sidebar, but we're almost done. Okay, we're almost done with the sidebar. Nestor agrees with that. Bloodworth is like, but this witness doesn't know anything about that. Court's like, oh, yeah. And then Nestor's like, then why are we even asking her? The judge, well, because she was able to. Lots of talking over here, but essentially the reason why she's able to answer this is because she is able to read the results. Bloodworth is like, you know what? Fuck it. I'll just move on at this point. And court's like, okay. Nestor's like, just withdraw it. Bloodworth's like, I'll just move on. So that's what's happened. They were trying to rehab the question, was unable to. And then when they finally did, they're like, wait a second, she wasn't the one that actually performed the test. She just has the results. So she doesn't know the answer to X, Y, and Z anyway. So you know what? Bloodworth is like, I'm withdrawing. Okay, let's just be done with this. All right, moving on.
Ladies and gentlemen, thank you for your patience. Pause there for a minute. Mr. Bloodworth, I understand you would like to withdraw the state's last question?
Correct, John.
Okay. All I ask, folks, is that to the extent you wrote down the last question and the answer to it, just cross that out of your notepads.
What if they didn't write it in their notepads and then they forgot what that last question was? You got to tell them what to unhear.
Okay.
Miss Nestor is cross-examining Detective Woody. And remember, the theory is that Eric took these THC gummies that were somehow laced with fentanyl. And that is why she is bringing this back into the jury's mind. You know, a lot of us are thinking, who the hell is going to sell some gummies with lacing it with fentanyl?
Are you aware that a few months after Eric's death, an individual was arrested and charged with selling marijuana laced with fentanyl?
Objection, Your Honor. Foundation.
I'm asking if she's aware.
Yeah, the hypothetical needs some foundation.
Do you recall a case that, actually, Katie, can you bring up Just a minute, Your Honor. Let me get the number.
All right, sidebar, the court. Katie, my apologies. Will you put it up on the first page? Would you go to the second page, Katie? Third page? Ms. Nestor. So here's why we're getting to this. The search warrant was provided to Gabler, I believe by her. I got to lay that foundation, but Gabler had that in his investigation report, and there are news articles about Summit County arresting this individual a few months later for allegations that he was selling marijuana that was laced with fentanyl here in the county. Bloodworth. I'm not even sure I saw the foundation. Bloody Starkey. I can tell you how the story ends, though, is that there was an NIK testing that showed there was fentanyl in the marijuana, and when they ran a confirmatory test, there was no fentanyl in the marijuana. I don't even think we have all that. We have to get all the way through the end of the story. I don't think there's foundation. Inaudible. Miss Nestor. Well, it's not hypothetical. It did happen. The court. Well, I mean, you have to lay more foundation for Miss Nestor, giving it to Gabler. The court. Having this search warrant affidavit, giving it to Gabler. Okay, I'll do that. The court. Which would, hear me out for a second, which would show that she had a search warrant affidavit that had a paragraph in it that states an individual contacted Summit County Dispatch stating, inaudible, but then I got to let the state to go in at the end. But I got to let the state go to the end of the story. You know, honestly, for me, it's like, what's the point of even bringing this up then? Because if she brings up the story, it's like, oh my gosh, there was fentanyl in marijuana. And then the end of the story was that, oh, there was not fentanyl in the marijuana. It's almost like, what are we doing here? Are these just distractors that are going to later on be rebutted anyway? Ms. Nestor, okay, that's fine. The court's like, you sure? Yeah, I'm mainly interested in her giving it to Gabler. I don't care so much about, I'm mainly interested in her giving Gabler reports of people getting arrested with fentanyl. I think she did that. Okay. Because they weren't inaudible. That's what I'm trying to do. Mr. Bloodworth. I think, well, let's see if you can lay foundation. I don't think that's accurate at all. Okay, let's find out. But we've got to start with this document. All right. So I think we'll play just a little bit more footage for this.
Did you ever provide to investigator Gabler, the private investigator, reports from cases where people were being arrested for dealing fentanyl in Summit County?
That doesn't sound familiar.
So that if he got those, they did not come from you.
I don't believe so. That doesn't sound familiar.
Totally fair. Did you know that Kouri Richins was represented by an attorney shortly around the time that you did the search on April 13th?
Objection, Your Honor.
Relevance?
Relevance, yeah.
Sustained.
When you had the conversation with Kouri on the day of the search on April 13th and you told her that Eric had, in your opinion, died of a fentanyl overdose, had she been trying to set up with you that week a meeting with her and her attorney?
Objection, Your Honor. Can we approach?
Yeah.
This goes right next to the next sidebar. Mr. Bloodworth. I really want to have the discussion that if she answers that question, in the state's view, she's opening the door to a discussion involving her invocation of the Fifth Amendment because, Miss Nestor, the Fifth Amendment? Mr. Bloodworth, Sky invoked it on her behalf. Sky, Miss Nestor, she'll have to. The court attempted to, right? Yeah. Mr. Bloodworth, what's that? Attempted to afterwards, right? After the search, Mr. Bloodworth. Even before. As I understand that, Detective Woody was trying to set up an interview through Sky, and Sky kept saying no. So my sense is this off-the-rail stuff we need to stay away from. The court. I have a larger concern regarding relevance that I've already ruled as a matter of law that the Miss Nestor. Well, the reason is because it's going to come up with O'Driscoll. The fact that he went to her house and interviewed her knowing that she had an attorney, the court, that's not relevant either. I've ruled as a matter of law that the Sixth Amendment right to counsel hadn't attached yet. Miss Nestor. Okay, I'll move on. So going back to the Fifth Amendment, now that's where, you have a right to remain silent. Sky was the attorney that was representing Kouri before. Before Kouri was arrested, Sky was trying to say that like, hey, Kouri has an attorney representing her. But then remember when O'Driscoll, the detective that took over after Woody, Well, he showed up at Kouri's house, was like, hey, I'm the new detective. Kouri invites us into the house. And the defense was trying to fight that. Well, Sky had already invoked Kouri's Sixth Amendment right, saying that she has a attorney needs to be present, that she doesn't have to, a Sixth Amendment right, for a right to counsel. But the judge was like, hey, I ruled already, Miss Nestor, that hadn't attached yet because that Kouri was not she wasn't arrested at that point and she wasn't in custody. So Kouri was the one that invited the detectives in and she wanted to yap away. Sucks for her. Our last witness of the day, one of my favorites, Todd Gabler. If you have not seen the video that we made of this private detective's examination and cross-examination, you guys need to watch it. He was probably one of my top favorite witnesses in any trial. Yeah, he's pretty up there. I would say up there with Spicy Draco, if you guys know who that is. Now, we're in the middle of his cross-examination by Miss Nestor. Oh boy, Miss Nestor's got a full day ahead of her, or she had a full day today. She must be really tired. Now, we are going to look at, I think, some February 14th calls that Eric may have made. This was when Eric was allegedly poisoned, or I guess not alleged anymore, right? Because she's convicted. I don't say alleged anymore. Where Kouri attempted to poison Eric with fentanyl. Eric ate a sandwich, felt really sick, and he had to sleep it off.
This is an outgoing call from Eric Richins' phone on March the 9th of 2022. I'm sorry, February the 14th of 2022 at 12:23, 2 minutes before the first record that we talked about, and that is to a different number, 801-473-5058.
So as part of your investigation that you were doing on the mirror phone, you could at least identify a call that was made by Eric at 12:23 p.m. on February 14th, right?
I'm confused. We're looking at an invoice record from a carrier, and you're asking me about his phone. Those are two different things.
Did this invoice come from his phone?
No.
Billing records?
From his carrier, from Verizon.
Right.
That's not a record from his phone. That's a record from his carrier.
I understand.
Two different things.
So according to the bill from his carrier,
Yeah.
he made a call at 12:23 p.m. on February 14th.
I'm confused. We're looking at an invoice record from a carrier, and you're asking me about his phone. Those are two different things.
Did this invoice come from his phone?
No.
Billing records?
From his carrier, from Verizon.
Right.
That's not a record from his phone. That's a record from his carrier.
I understand.
Two different things.
So according to the bill from his carrier,
Yeah.
he made a call at 12:23 p.m. on February 14th.
Correct.
Okay.
Objection. There's a 901 problem here.
I'm done with it, Your Honor.
Hold on. You got to approach for a moment, if you would.
There's
Let's see what's happening in sidebar. The court. Do you want to just reserve that for the time being? I'm not sure there's actually a 901 problem if you had a moment to look at it. But I understand that you're not looking at the same call records. Mr. Bloodworth. Oh, what was 901 again? I feel like I looked this up. Something about whether or not you can verify or if you can authenticate. Yes, authenticate evidence. All right. 901. Mr. Bloodworth. Yeah, I'm not entirely sure what this is. There's also no inaudible authenticity. We have the call records from the carrier. Right. I guess what I'm saying is if you look at those and this is accurate, may we just all glide over this for the time being, or is there anything we need? Well, I think the problem is I can recheck this, but I don't think this is accurate when you compare it to the call records. If that's the case, I think the remedy would be for me to give the jury an instruction the same as I could do right now, but we could confirm whether it's correct or not before I give the instruction, right? Understood. That's what they're going to do instead. Now that is it for today's sidebar. Oh man, I feel like these sidebar days are getting lengthier and lengthier. We've got, I think, about 4 more days until we're done with all the sidebars. And bye, Mr. Todd Gabler. Thank you so much for testifying. We enjoyed you. I hope he's healed. I hope he's all recovered, and I hope he's doing well. But guys, that is it for today. If you guys haven't already, hit the like button if you guys enjoyed this. Feel free to subscribe. And, when we do the live streams, feel free to stop by and say hello. Let me know which video brought you guys in, or if you guys found me on a different platform or something like that. Although, mainly, it's just on YouTube. Alrighty, guys. Enjoy the rest of your weekend. Take care and feel free to join the Discord if you guys want to and have your notifications on. All right, guys. See you guys later. Bye-bye.